All right. We're going to start out with some credit maxims. All right. Now, when I was first turned on to Maxims by one of my mentors, he sent me volumes of Maxims from Anderson's to Plubert's to uh, uh, Lord Coke. I mean, you name it. He sent me books that have over 16,000 maxims in some books, just and the Latin expression as well as the converted English expression. And again, maxims are just short, pithy sentences. People will say, "Oh, it's not law." Granted, it may not be law. It could be said that it is sound doctrine and principle. Um, And as I started to read through these maxims, I got really excited. I started to see a path outside of the statutes, codes, city ordinances, rules, and regulations that may lead to a remedy that's viable, because these short, pithy sentences, um, they really just capture everything in a nutshell when you find them. I find I enjoy using maxims. Uh, if depending on the situation, but if I'm around some people that are intellectually inclined, I enjoy making powerful statements with just one sentence and then shutting the fuck up. It's a fantastic way to establish yourself within a community of people that have perhaps superior intellect. All right, and it's nice to be able to carry and hold your own, and you made your poignant point with one sentence, and you don't need to expand upon it in order to gain acknowledgement per se, right? So these maxims I love using, and the more that I study court cases, the more I find that during the conclusions of the court cases, so often, not all the time, but so often, there is within the conclusion these maxims that start to appear, and I'm like, oh my gosh, wow. No wonder these conclusions sound so brilliant. These maxims have been around for thousands of years. And many people have tried to challenge these maxims and to be honest with you, fail horribly because they're just so sound. So I want to share these maxims with you. And we have maxims for judges. We have maxims for contract. We have maxims for banking. There's maxims for the exclusive jurisdiction of equity. And as I started to study these massive books of maxims, I found maxims that were very beneficial to my cause and resonated with my mind, body, spirit, and soul. And I was like, this is the ticket. This is the answer. This is what I'm going to move forward with. Statutes and codes being vague and ambiguous, using pronouns you, it, that, this, the, he, she, it, you. Those are all vague and ambiguous. Okay, they don't actually point to a man or a woman. Person again is vague and ambiguous. Person is an individual, a corporation, an unincorporated corporation, a joint business venture, partnership, a trust. Okay, so person is vague and ambiguous in the aspect that it describes multiple things. Where it's not vague and ambiguous is the fact that it only describes things, okay? Doesn't actually describe the living, it describes things. And things don't breathe, eat, shit, and die, all right? Things are whether they're tangible or intangible, they're just things nonetheless. So as I was reading these maxims, I called up my buddy. I was all excited, and then I kept reading in this book, and I started to get to maxims that really struck a nerve with me because they started to look rather sinister. And I called him up and I said, dude, fuck, I thought you gave me the Holy Grail here, and now I'm reading these other maxims, and they don't make any fucking sense. They don't resonate with my mind, my body, my spirit, my soul. What the fuck's going on here, buddy? And he goes, oh, you run into the commercial maxims. I was like, that makes sense. He goes, yeah, you've hit the commercial maxims now. And I go, okay, so there's a difference in these maxims. Is absolutely. He goes, and that's why those don't resonate with you. And he goes, and that's why when I go through these books, I pick out and choose the ones that resonate with me and that I can stand upon. I said, okay, perfect. And he goes, and I put these in my pleadings. I put these in my negative averments. I put them in my demurs. I put them in my request for admissions. I put them in everything. Everything. Closing arguments. He goes, I lace every document with Maxims. And I thought that was really brilliant. And so that's how I got turned on to Maxims, and I want to share some of these with you. But again, these pertain to creditors, credit, okay? A human body is not susceptible of appraisement. What does that mean? You can't put a value on the human body, period. Today you could be seemingly worth nothing. Tomorrow you could have an idea that revolutionizes the world. What's your body worth? Okay? You can't put a value on it. You can't put a value on life. It's exponential. It's infinity, beyond infinity, in fact. Okay? A creditor who permits property to be sold gives up the pledge. Now, I really like this maxim. This maxim is something that I would be using in like a foreclosure, a credit card issue where they have transferred it to a third-party debt collector, right? That I don't have a contract with, not to mention that the credit in and of itself in the first instance was my credit, and we can prove that by a motion to compel for discovery or whatever if it ends up in the court. You can do it in the private administrative process. I conditionally accept your offer, provided that you can prove your claim. And you can go through a litany of things that you require for them to prove their claim, all right? And so again, that maxim is a creditor who permits property to be sold gives up the pledge. Now, so often in foreclosures, you'll see that the bank will say something absolutely heinous. And what it actually means compared to what you think it means are two different things. The bank will so often say, well, we lost the note. Well, how irresponsible is that? You mean to tell me that you lost a vital record of a vital nature that was an instrument, a negotiable instrument? I wonder who should be liable for that, right? And again, if you lost the note and you're openly admitting or omitting that you lost the note, depending on which way you answer the negative averments or the affidavits that are submitted to you, that begs the question, are you the holder in due course anymore? If you lost the note, then it's presumable and perceivable that it could be blowing around in the wind and some guy 600 miles away could pick it up one day, read it, realize what the fuck it is, and go, hey, I'm going to this house and I'm going to knock on the door and tell this son of a bitch he owes me because I got the note in my hand. I am the holder in due course. Okay, so you can shut the bankers down. When they say they lost the note, that's funny. That's funny. How irresponsible are you people, and why should I continue to do business with you people when you can't even keep track of your notes? All right? That which, when given through mistake, can be recovered back. When given with knowledge of the facts, becomes a gift. Okay? So, that which, when given through mistake, can be recovered back. When given with knowledge of the facts, becomes a gift. Are you knowingly, willingly, and intentionally volunteering to pay taxes? And that's a gift. It's a class 5 gift and estate tax. All right? So you're not entitled to recovering that. Same thing with Social Security. Are you knowingly, willingly, and intentionally donating to Social Security, which quite honestly is a scam? Well, then it's a gift, and you're not entitled to it back, all right? That's why when they implemented the Social Security Act, they robbed it almost immediately. Almost immediately, they started stealing from it and borrowing against it, and it's just funny. He who does not know what he ought to pay does not want probity in not paying, okay? So if you're not clear, concise, you can't explain to a T what somebody owes you and what species they're to pay you in, that man or woman who's inquiring does not want probity in not paying, all right? Money refused liberates the debtor. Okay, that's 9 Cokes Report 79, 2,194 in the book. Okay, and it's pretty self-explanatory. That's why I love Maxims. They're just so short, sweet, to the fucking point. It's not even funny. Money refused liberates the debtor. Let's say that we have an agreement. Let's say you agreed to mow my yard for $60. We strike up a good conversation. The's a good vibe. You're having a wonderful day. Maybe you won a scratch lotto ticket for $300 and you're just happier than a fat hog eating shit. All right. And you go, hey, Derek, you know what? I know that I said that, you owe me $60 for mowing your yard, but I am having such a fantastic fucking day, dude. I just won $300. I'm happier than a fucking shithouse crazy rat right now. I'm nuttier than squirrel shit. I am fucking elated. I'm going to take the rest of the day off. And I'll tell you what, buddy, this one's on me. Now, a week later, he runs into some hard times and, he's got a hot date. And he's got a negative bank account, and he's worried about being overdrawn, and he comes back and beats on my door. Hey, Derek, the other day I mowed your yard, and, yeah? Well, you still owe me $60. Well, wait a minute here, partner. You said earlier that I didn't owe you anything. You were happier than a hog eating shit, and that you'd won $300, and this one was on you. Why the change of heart? I've come into some hard times. Well, it's not that I offered to pay at that point, but rather the fact that he turned around and said that there was no need to pay. It was on him. All right. So that liberated me in that instance. Now let's reverse this situation here. Let's say I offer to pay him the $60, right? And he says, no, don't worry about it. This one's on me. That liberates the debtor. There's another way this happens. Let's say I offer you real gold or silver, and you work for the government, and nothing shall be coined other than gold or silver for the tendering of payment of a debt. So says the Constitution for the United States of America, and furthermore, every state constitution says the same. Every one of them. Okay? That's found in Article 1, Section 10 in the United States Constitution. When you look at Nebraska's Constitution, it's Article 1, Section 16, and for the rest of the 50 states, you will have to go and look for yourself. When I offer that tendering of payment to them, and they refuse it, they now become the surety for any alleged debt that may be in existence. Okay? Now, when they're telling you that there's a fee for services, well, you should probably inquire about the true bill due and owing, because before you can get paid for your services, you have to render those services first. And the government, with their sleight of hand, manipulates the situation to say, oh, no, you pay in advance for our services. And then so often goes, oh, yep, we did our due diligence, and unfortunately you don't qualify. Well, what about the funds that I gave you? What about the permissible units? What about the wherewithal that I gave you? Oh, yeah, you forfeit that. There's no guarantee that you get anything from us when you give us whatever you perceived to be what we were asking for. We don't actually return that to you, even if we've erred in our decision or whatever. So really, it's they're worse than doing business with the mob. The mob's at least honorable people. The government are a sinister bunch of cretins and actors. They're predators preying on people. Okay, so money refused liberates the debtor. I'm not sure exactly when this maxim was created, because there was a few of them before Lord Coke that say the similar thing, just with different words. Let's see here. Here's Plubert, Harvard University. I'm not going to go through that one. Let's do this. That was judgeships. Let's Let's see if this one will. Steinman's Vouchers, Conscience Law Dictionary. No. Another Plubert's Dictionary. Don't want that one. Where are the rest of my cheat sheets on Maxims? 1 second here, ladies and gentlemen. I will try to find my cheat sheets. Ah, there they are. Bingo, bingo, bingo. Gibson's Maxims. What do you guys want to hear? The Maxims on evidence here real quick. The 3-sheet little cheat sheet here, created by one of my mentors who spends countless hours and days just going through books, reading, and then he puts these little cheat sheets together to help me out navigate these waters that we're in. And I hope that they find you well and in good spirit and help you as well. These maxims are geared towards evidence, facts, and truth. Maxims by S.S. Plubert, that's P-E-L-O-U-B-E-T, and I'm not sure that I'm saying that right. I just pronounce it Plubert. Whether it's Plubert or not, I don't know. Published in 1880. Evidence. The absence of him who is employed in the service of the state ought not to be prejudicial to him nor to others. The burden of proof lies with the plaintiff, the onus of probandi. Suspicion rests strongly on the unfortunate side. He who affirms, not he who denies, must bear the burden of proof. Okay, so he who is making the statement has the burden of proof, not the one who denies. He who affirms must prove. An affirmative implies a negative. To deny one thing is to admit 1,000 others, ladies and gentlemen. Okay? The inclusion of one thing excludes all others. He who alleges contradictory things is not to be heard. That's Jenkins Centuries or Reports 16. One alleging his own infamy is not to be heard. Fourth Institutes of Lord Coke 479. That ought not to be alleged, which is proved would not be relevant. Hear the other side. The opinions of philosophers, physicians, and poets are to be received and alleged in causes. A confession made in judicial proceedings is of greater force than all proof. Meaning, if you confess to something during an interrogation or within the scope of the judicial system, that confession is greater than anybody else's statements. All right. Against fiction, proof is not to be admitted. Whosoever is skilled in his profession is to be believed. Where the proof of facts are present, what need is there of words? The proof lies upon him who affirms, not upon him who denies. He who excuses before he is accused establishes his own guilt. He who excuses before he is excused establishes his own guilt. If you're the first one to walk out of the courtroom, you lose. All right? Last man on the battlefield wins. The conclusion proves the fact. The termination, not the fight, crowns the victory. Extremes being proved, the medium things are presumed. No proof is incumbent upon him who denies a fact. The faculty of proofs is not to be narrowed. It is vain to prove that which, when proven, is not relevant. To speak insufficiently is the same thing as to say nothing. Not to exist and not to appear are the same thing. What does not appear and what does not exist are the same. It is not the defect. It is not the defect of the law, but want of proof. In things obvious, there is no room for conjecture. In criminal cases, the proofs ought to be clearer than the light. In general, whosoever says anything, whether plaintiff or defendant, must prove it. All right? That's why if you're the defendant, it's probably best to ask questions. It's probably best to do a negative averment, right? It's probably best to do a request for admissions. It's probably in your favor to maybe do a demur, all right? In law, no one is credited unless he is sworn. That's right. All those pleadings that are unsworn, unverifiable, by unknown, unverifiable, unregistered people, all right, they're of no consequence. They should be impeached immediately based upon the grounds that you are being denied due process of law. They are not following the law. They are not applying or presenting their full commercial capacity and their full personal liability. And yet you, in your capacity as a man, assume full liability, okay? In things manifest, he errs who alleges the authorities of law, because obvious truths need not be proved. What goes up must go down. I don't have to fucking prove it. It's a fact, all right? Family documents or memoranda, when not sustained by other evidence, are not of themselves sufficient proofs, okay? The judge should decide according to the allegations and the proofs. It is the duty of a judge to decide according to the facts alleged and proved. Jurors ought to be neighbors of sufficient estate and free from suspicion, meaning that you're right to a trial by jury, not jury trial, and you're right to have your jury of your peers. Your jury of your peers are supposed to be coming from your neck of the woods, your neighborhood. Like, love, or hate you, or any different, they understand a little bit about you. They understand what your character's like, all right? And those are the people that are supposed to say, yeah, that guy, he definitely broke the law, and we can say that it was more than likely with intent. We watched that little shithead grow up, had to chase him down the road. You know, he used to sneak out my daughter's window. That son of a bitch, he's a scoundrel, right? The law admits no proof against that which is presumes. Things manifest need no proof. To lie is to go against the mind. Women ought not to be admitted to proof of the estate of a man. Denial cannot be proved. No one alleging his own baseness is to be heard. No one at the point of death is presumed to lie. No one can verify by jury against a record. No one is presumed to trifle at the point of death. No one is bound to arm his adversary against himself. Fourth Amendment, Fifth Amendment, Sixth Amendment, right? We're paying attention here. No one is bound to arm his adversary against himself. They send you some documents, and they just can't wait for you to make a bunch of statements back to them. I never did this. You're liars. Blah, 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 blah. All while absconding from what you should be doing, which should be asking the proper questions for the verifiable proof under the pains and penalties of perjury under full commercial and personal liability of the man or woman aggrieved making the alleged allegation, right? That might be a little better way of going about it. No one is bound to foretell. No one is bound to produce writings against himself. No one who is ignorant is bound to give information, but everyone ought to know that of which he gives information. No one is bound to testify to his own baseness. No one is bound to expose himself. No one is bound to accuse himself. No man shall set up his infamy as a defense. The reference is not to be credited unless the thing referred to be proved. That cannot be proved, which when proved is irrelevant. That which is gathered from equivalent expressions is of no consequence. Nothing is falsely concluded. The embracement of a witness proceeds from his respect of an oath, or for an oath, and his dread of perjury. Things opposite, when placed together, appear in a clear light. The best evidence of the matter will prevail. Plain truths need not to be proved. One eyewitness is better than 10 ear witnesses. So somebody who sees something is better than somebody that heard something. 2 eyes see more than one. Witnesses are weighed, not counted. One of 2 opposite positions being affirmed, the other is denied. Strong presumption is full proof. Strong presumption is of weight in law. Presumptions are conjectures from probable proof assumed for purposes of evidence. Under pretext of legality, what is illegal ought not to be admitted. The necessity of proving lies upon him who sues. Proofs ought to be evident, that is clear and easily understood. The extremes being proved, the intermediate proceedings are presumed. Let him who accuses be of clear fame, not criminal. He who does not freely speak truth is a betrayer of the truth. That covers most lawyers. He who says all excludes nothing. He who is silent does not thereby confess, yet it is true that he does not deny. What appears clear need not be proved. What appears to the court needs not the help of witnesses. What has been admitted against the reason of the law is not to be drawn into precedent. That which does not appear does not exist. What is not read is not believed. What is proved by record should not be denied. An infamous person is prevented from taking an oath. Let the principal answer. The answer of one witness shall not be heard at all. Remember, it takes 2 or more witnesses to corroborate the alleged incident, right? The presumption is always in favor of one who denies. Silence shows consent. A presumption shall stand until the contrary is proved. Where the number of witnesses is equal on both sides, the more worthy are to be believed. Credence is to be given to the witness, not to the testimony. Evidences are to be weighed, not numbered. The answer of one witness shall not be heard at all. Every principle is its own evidence, and plain truths are not to be proved. Plain truths need not be proved. Violent presumption is sometimes full proof. When the law presumes the affirmative, the negative is to be proved. A fact does not necessarily constitute a right. The conclusion proves the fact. The termination, not the fight, crowns the victory. Facts are more powerful than words. No proof is incumbent upon him who denies a fact. Jurors are the judges of the fact. Reason and authority are the 2 brightest lights in the world. Unforeseen. An unforeseen fact is held as no fact. Suppression of. The suppression of a fact takes away equity, truth. A custom, though it be of great authority, should never, however, be prejudicial to manifest truth. The law never permits anything contrary to truth. Painted error appears in many things more probable than naked truth, and very frequently conquers truth by reasoning. Fiction yields to truth. Where there is truth, fiction of law does not exist. Fiction is against the truth, but it is to be esteemed truth. Justice knows neither father nor mother. Justice regards truth alone. Law favoreth truth, faith, and certainty. We can do nothing against truth. Plain truths need not to be proved. He who does not freely speak truth is a betrayer of the truth. The truth of the descriptions removes the errors of the name. Truth fears nothing but concealment. By too much altercation, truth is lost. The truth of the name removes the error of the description. Truth which is not sufficiently defended is oppressed. He who does not speak the truth freely is a traitor to the truth. In things manifest he errs who alleges the authorities of law, because obvious truth need not be proved. In judgment, judgments are, as it were, the saying of the law, and are received as truth. The decision of the 12 good and upright men is thought by the common law of England to be the dictate of truth. A judgment is always to be taken for truth. Suppression of the truth is equal to the expression of the false. Suppression of the truth equals the suggestion of the false. Oh, what do we do? Do we do necessity or do we do agreements and contracts? Let's do agreements and contracts. It would seem that that might be most beneficial for everybody. Shoo-ba-doo-ba-doo. Now, again, you guys can use these in your documents. I'm not reading what books they've come out of. These come out of all kinds of different books that my brother James, one of my mentors, has shared with me. I have volumes of them. They're all in the law library. Anderson's, Bluebird's. There's just so many of them to name. I couldn't possibly go through them all. And like I said, each volume has 16,000 plus Maxims in them, and they're absolutely awesome. So if you're a participating member in the law library, please look for the law library dictionaries, the dictionaries in the law library. And there's almost every dictionary you could think of is in there. Okay, and many of them have multiple volumes. Agreement, Contract, and Obligation Maxims by S.S. Bluebird, published 1880. Agreements, generally, an indictment of the parties shall be ordered according to the law. Good faith demands that what is agreed upon shall be done. All right, that's clean hands doctrine right there. All summed up in one pithy short sentence that nobody can argue. Good faith demands that what is agreed upon shall be done. Back in the day when you shook a man's hand, you consummated a contract, an agreement, although not in written form. There was a trust that was created. There was sufficient grounds of expectation and consideration and value given. Okay? The agreement of the parties makes the law of the contract. Remember, contract makes the law, equity follows the law. That's why ignorance of the law excuses no man, for we are all responsible for knowing the contracts we enter into. The agreement of the parties makes the law of the contract. All right. So in trust law, it would be like your trust indenture. Your trust indenture is the law of the trust. All right. The agreement of the parties makes the law of the contract. An agreement conquers law. The meeting of the minds of two or more in an agreement makes a contract. In contracts, when the question is what was agreed upon, the words of the agreement are to be interpreted against the questioner. Okay? Many promises lessen faith. A naked agreement is sufficient for an action. It cannot be affected by any agreement that there is no accountability for fraud. Ambiguous. Ambiguous agreements are to be interpreted against the seller. Now, this is an important topic that we should touch upon. This one sentence pretty much nails it. But let's break it down and help people really understand. I'm pretty well versed in creating different instruments and contracts, and you will still find, sorry buddy, making a video. You will still find that when I come to an accord with people, so often I will allow them to write the contract. And the reason that I do that, even being as versed as I am in it, is I am a man. I will at some point inevitably make a mistake, and that's duly noted due in part to my past where I have made mistakes, right? So I recognize that. So I will allow the other party to make the contract, and if they make the contract and it's written up and it's vague and it's ambiguous, they bear the advantage from that ambiguity, so they also bear the disadvantage or the burden when I choose to walk away from it because it wasn't with full disclosure. The contract wasn't written properly, right? Now, I'm a man of honor. I'm a man of my word. If I make an agreement with you, we're going to follow through with it. But should there be some type of issue, the one who wrote the contract is the one who's liable at the end of the day, okay? That burden falls back on them because they wrote the actual contract. Remember, the one who's offering the contract is always the debtor, and the one that's receiving the contract is the creditor. In that situation, the creditor always has the ability to dictate the terms and conditions, all right? And here's some proof of that. I think it was, and correct me if I'm wrong out there, listeners, I think it was Nixon that was famous for the red line veto. He would always run his pen through shit and just cross it out and initial it. You ain't putting that pork belly shit in this bill. That ain't going in there. That ain't going in there. That ain't going in there. And then he would send it back to the legislator, right? Send it back to the Congress and the legislator. Screw you guys. You're not putting all this pork belly shit in here. I'm not signing off on that. Okay? They were the ones making the offer. He's the one that's going to ultimately accept it and put a signature on it. And because of that, he gets to dictate what will and will not be in that fucking bill. All right? And so he's redlining, vetoing shit he don't like. And this was exemplified by a young woman who the prosecuting attorney wanted to make a deal with her. She said, fucking A, Scooter, shoot me your deal. Well, he slid her a piece of paper in the court, and she looked at it and said, he's not making an offer, Your Honor. This guy's over here jerking everybody's chain around. He ain't serious. He didn't make me an offer to negotiate a deal. Well, what do you mean? He didn't sign this thing. I just said, well, give it back to him. She gave it back to him. He said, you gonna make this woman a real offer? You gonna sign your name to that or what? Sure, yeah, no problem, Judge. He signs his name to it and hands it back to her. She says, all right, I just need to leave the court for about a few minutes here. I just need to take this under advisement real quick, make sure I read it and understand it. You don't ever want to be in the courtroom while you're doing your decision making. You don't want to feel pressure. You don't want these people staring at you. And are you done yet? Come on, have you read that yet? Don't let them do that shit to you like car salesmen, them fucking assholes. Take leave of court. If they won't give you a leave of court, they can't deny you a drink of water, and they can't deny you to go take a piss. All right, I gotta go defecate or take a piss. I'm out. That's just how it is. Tough shit. And take your paper with you. Okay, you can go outside and phone a friend, because remember, seeking counsel after the fact is always in vain. After you've signed the deal, the deed is done, baby. It's done. All right. So, make sure to seek competent counsel or whoever you trust, right? Step outside the courtroom, make your phone call. Hey, what's going on? I got this document in front of me. This is what it says. And this is what this gal did. She went through and she redlined out everywhere that there were things that were not beneficial to her. So, for example, it said 6 months in jail. She redlined that out and put 0 days in jail. And then she turned around, she read a little bit further and said $1,000 restitution. She crossed that out and said $0 restitution. And then she read down a little bit further and said 6 months probation. She said 0 days probation. And then she turned around and signed it. This is contract law 101, people. Right? This is real shit. This is not a joke. This is an offer. And this prosecutor can fall into commercial dishonor over this deal. All right. He's got his wedding signature on it. This is what he's agreed to. He's made the offer. But because you know the law and you understand that you have the ability to negate anything that is not beneficial to you and then sign it, she walked right back in, handed the paper to the bailiff, said, go ahead and hand that to the judge. I agree. Deal's done. Prosecutor didn't realize what she had done. Judge says, you object? Nope. Don't object. Judge said, okay. This case is closed. Get out of here. Well, wait a minute, Your Honor. What about, the deal here? Well, we're going to honor that deal. 0 days in jail, 0 restitution, and 0 months of probation. That's the deal. You agreed to it. You signed it. She stipulated to what she was willing to stipulate to in this contract, this deal that was presented, and you agreed to it. So, deal's done. Case is closed. This matter's settled. It's over. Now, you can't do that unless I actually put the offer to you in writing. A verbal offer is bullshit in the court system. Make them put it in fucking writing and sign their name to it. Anyway, moving on. In contracting a sale, an ambiguous agreement is to be interpreted against the seller. When of value, an agreement avails no one unless he is a party or privy to it. An agreement not to take ties avails not. When odious, some agreements are odious, but mostly those against matrimony and commerce. Intentions in agreements, the rule is to regard the intention of the contracting parties rather than their words. How confirmed? Agreements are confirmed by delivery. Contracts generally. A contract is, as it were, act against act. Debt and contract are of no place. By fraud or dole, a contract perishes. That's Broom's Legal Maxims 731. I also have that in law library online through selfgovernanceU.com. The meeting of the minds of two or more in an agreement makes a contract. From a wrong, no contract can arise. The contract makes the law. That's found in 2 Bouvier's, and it's again Law Dictionary. Bouvier's Law Dictionary 135, and then it's 22 Wendell's New York Reports 215, 233. It says the same thing again. Nothing shall be void which by possibility may be good. All contracts made under a law perish under a contrary law. Agreements give the law to the contract. By a contract, something is permitted, which, without it, could not be admitted. He who contracts with another either is or ought to be not ignorant of his condition. That which bars those who have contracted will bar their successors also. The beginning and cause of every contract must be considered. When understood, a contract should be understood according to the intentions of the parties expressed in words. In contracts, the interpretation should be liberal, in wills more liberal, and in restitution most liberal. In contracting a sale, an ambiguous agreement is to be interpreted against the seller. In all contracts, whether manded or not, an exchange is understood. In contracts, when the question is what was agreed upon, the words of the agreement are to be interpreted against the questioner. The place of the contract governs the act. Jurisdiction. Right there in one short pithy sentence. The place of the contract governs the act. That's a jurisdiction issue. Every dishonorable contract is odious to the laws. Contracts which are not against law and do not originate in fraud are in all respects to be observed. That contracts which are made against law or against good morals have no force is a principle of undoubted law. The prescription and execution of a contract do not affect the validity of the contract, but the time and manner of bringing an action. When null, when a contract is null, a contract with a base consideration or against good morals is null. A contract of a minor is invalid if it led to his injury. Law of contract. The agreement of the parties makes the law of the contract. Regularly, a contract not to alienate my property is not valid. Where made. Every person is understood to have contracted in that place in which he has bound himself to pay. Of debtors, the right to sue of creditors can neither be taken away nor diminished by the contracts of their debtors. Nude. From a nude contract, i.e. a contract without consideration, an action does not arise. A naked promise does not make an obligation. A naked contract is where there is no consideration to support the agreement, but where there is a consideration, an obligation exists and produces an action. An illegal contract. No action can arise from an illegal contract. An immoral contract. No action arises from an immoral contract. That's also supported in the Bible. So this maxim may have very well come from the Bible. Contracts founded upon an immoral consideration are not to be observed. Remember, the only way out of a contract, biblically speaking, is if it is found to be immoral, right? Unconscionable. For a loan, if in a contract for a loan, a clause is inserted that fraud should not be accounted of, such clause is void. Oh, baby. What can you do with that? How many of you actually read your mortgage paperwork and contracts and agreement and it says, if fraud is discovered in this later on, the bank is exempt from suit and you are barred from claim? How many of you read that shit? I have, because I read a lot of this fucking shit and I just fucking die laughing at how gullible people are. And then you get in court and go, well, did you sign this? Yeah, I signed it. Okay. You signed this then. Did you read it? Well, not really. Okay, but did you read this line right here where it said that you were barred from bringing suit or a counterclaim if in the event that they have lost the note, committed fraud, or you discover fraud within the contract? Did you read that? No. Well, no. Okay, well, then you're barred from your claim. I'm sorry. No, Judge. For a loan, if in a contract for a loan a clause is inserted that fraud should not be accounted of, such clause is void. Digest of Pandex of Justinian 13.7.17, Your Honor. You want to argue with that? I'll take that under advisement, and I'll let you know what I think about it later on. I'm going to go back into my chambers here because I've never really seen that one before, but I'm going to go look it up. If it's there, I'll think about how I'm going to make my decision. I'll let you know what the court says. See, being sharp and using short, pithy sentences so often will help you avert tragedy, okay? So again, I'm going to read that maxim again because it's in every fucking loan contract, every fucking mortgage fucking contract. It's there, okay? Go read the documents. It sticks out like a sore fucking thumb. If in a contract for a loan, okay, remember there never was a loan in the first place. If anybody loaned anything to anybody, you loan them your life source energy through the Social Security person, which is the account that they draw the funds from, right? If in a contract for a loan, a clause is inserted that fraud should not be accounted of, such clause is void. Period. That's sound doctrine, sound law, sound principle, and the maxim supports it, all right? Things implied. In contracts, those things which are of custom and usage are tacitly implied. I can't tell you how many times we've had a banker on the stand and he says, well, Judge, that's just customarily how the bank does business, Your Honor. Custom kind of creates the law, does it not? Only if the defendant doesn't stand up and fucking object does that agreement continue on throughout the case. You should always object when anybody's testifying saying, well, that's just customarily how we do things. I don't give a shit how you customarily do things. Fuck off. If it's against the law, it's against the law. All right. And if it violated my rights by your customary actions, then that goes to show that you are consistently violating other people's rights in your customary actions, and I'm here to fucking stop you from doing that to everybody else. In fact, I'm here to let the world know that if they've had it done to them because that's your customary practice, that they've been taken in the shorts without any lubrication, they should come on down here and bring suit too, right? Okay. That's how we keep free people free right there, is by informing and showing others how to walk the walk and talk the talk. When made, in contracts, reference should be had to the time at which they were made. Private contracts cannot derogate from public right. Mutual contracts bind either both parties or neither one at all. Either both parties are bound by it or nobody is bound by it, all right? Obligations. An obligation which has been sealed in due form is extinguished if it fall into the state from which it cannot arise. There is no obligation to perform impossibilities. I use this one a lot. I like this one. And here's why. All you got to do is pay $479. I agree. Dollars of what? Oh, come on now. We're not going to go down this path, Derek. Mr. Gonzalez, how dare you? Everybody knows what a dollar is. I don't. So therefore, there is no obligation to perform an impossibility. If you cannot specifically tell me what the fuck you're looking for payment, I'm under no obligation. Well, credit card, fine. Pull out an expired credit card and hand it to them. There you go. Use it. It's yours. That's what you wanted for payment, a credit card, and I gave you a fucking credit card. Payment's made. And if you refuse that credit card at this point, then, offering a tendering of payment made and refused liberates the debtor. Fuck off. All right? Oh, well, we're not going to accept that. Okay, great. So you accept the liability for the debt if there even is a debt, which I know there isn't a debt. All right? So you are now the surety because an offering a tendering of payment made and refused liberates the debtor. So fuck off. Okay. Well, we accept checks. Fine. Give them a blank fucking check. Give them a blank fucking check. They didn't say you had to sign it. They didn't say you had to put anything on. We accept checks. Cool. Here you go. Here's a check. Here's a piece of tissue paper. Here's a fucking leaf from a maple tree. What else do you want? What else do you want? I give you whatever the fuck you want. All you got to do is be very, very specific about what you want, and I'll give it to you. Okay? Because you're creating an impossibility right now. So then let me show you what they'll do. They'll do one of these things. We want this, Derek. Do you know what that is? Well, it appears to be numbers and some type of symbol, but that's still not very specific. I'm still not sure what you're asking for. Can you describe it? Can you explain it to me? Can you be a little more specific? Because the numbers, although they may be a numeric value, I don't know. Maybe there is, maybe there isn't. Who's to say? Because again, what precedes the numbers is this fancy symbol that nobody in government can seem to explain. Isn't that interesting? So I don't see anything there. What are we in fucking Egypt? Are you giving me hieroglyphs? I don't understand how to fucking read that shit. I don't know what the fuck that means. Are you wanting me to presume and assume what you fucking want? And then you get to say, I like that nut, but I don't want that nut? No, fuck you. Tell me what the fuck you want specifically, right? Okay? And I know you guys think I'm being difficult, but that's the reality of the situation when you come out of fiction, all right? When you come out of the fog and you finally see what these fucking asshats are doing, you can have so much fun with these people, and I enjoy it. It's a lot of fucking fun. So, there is no obligation to perform impossibilities. In all obligations, that's why the state can't actually charge you taxes. You know, the case that I was recently in, it'll be overturned, by the way. It'll be vacated. It'll disappear in the wind. It'll be as though it never happened. Just watch. I haven't done anything with it yet because I don't have to. I think it's fucking funny. First of all, it doesn't even attach to me. It attaches to the estate. Okay. And the only thing that it's really evidence of is a financial commercial transaction for which somebody's liable for the transfer taxes under Title 26, 2603, 2602, 2001, 2002. Anybody in constructive possession of decedent estate property is liable for the transfer taxes on a carryover basis. Mm-hmm. Yep. You watch. The last case that I went through, it'll disappear like the fucking wind. All right. In all obligations in which a day is not fixed for payment, it is due on the present day. In all obligations in which a day is not fixed for payment, it is due on the present day. So you create a day without you create a contract without a day of execution. That's due right then and there. However, in order to create a proper contract, it must have a start date and an end date. A lot of people don't realize that. They write these requests for admissions. They'll do interrogatories. And they'll send them the interrogatories. The interrogatories will be beautiful. The request for admissions will be beautiful. The negative averment will be absolutely gorgeous. But you know what they fail to do? They fail to put at the very top, you have 10 days, you have 30 days, you have 20 days to respond, rebut, rebuke, or you admit to all of this. Okay? They failed to put that in there, and because of that, there's no directives. There's not a start date. They didn't date it. They didn't put their address on it. They didn't put their full legal name on it. They didn't put an email on it. They didn't give them a place or a location for them to reach out to them, right? And they didn't put in there specific instructions on how long they had from the date of receipt to respond back before they acquiesced to it. And so when you get into court, you're like, oh, I did an affidavit, I did a demur, I did this, I did that, I did the negative averment, I did all these things. I did a confession and avoidance, but you never stipulated the dates and the times for a proper, adequate response. And because you didn't do that, clock's still ticking, because technically there's no time limitation on it. So you got to put those time limitations in your documents so people understand, hey, you're under the gun right now. You got a certain amount of time or the hammer comes down on you. This is going to be admitted into evidence because your silence is equated to acquiescence, because I gave you full notice, full disclosure. I gave you due process of law. All right. That's something that a lot of people miss out on. An obligation without cause, or upon a false cause, or upon an unlawful cause, can have no effect. No one is compelled to substitute another in his own place. That means you can't, no one is compelled to be a surety for another. Okay, and the Bible also speaks about that as well. No one is bound by the advice he gives. All right, this is why you have a right to counsel. You have a right to counsel in a court. They'll tell you that you don't. I'm telling you, you fucking do. But the counsel, the one who gives you the counsel, all right, no one is bound by the advice he gives. Sometimes the people who give you the advice don't often follow their own advice. So ye be warned, right? No one is bound by the advice that he gives. No one is bound to know the private act of another unless done with himself. No one can be compelled into co-partnership against his will. No one is bound to an impossibility. No one is bound to arm his adversary against himself. No one is bound to foretell. No one who is ignorant is bound to give information, but everyone ought to know that of which he gives information. No one is bound to expose himself to misfortunes and dangers. Every word sincerely spoken constitutes an obligation. And with that said, I'm going to let you guys go. Like I said, if you guys want to get into these maxims real heavy, I have volumes and volumes of law dictionaries with nothing but maxims in them. And they are absolutely amazing. And they'll help you out in a lot of instances when creating documents or contracts or just trying to have a good articulate conversation with somebody. Instead of rambling on, you can just say a few short pithy sentences and you made your fucking point spot on. Everybody's like, wow, that was pretty philosophical and genius. I must say, it's clairvoyant and direct and to the point, and wow, very enlightening. You'd be surprised how many people are just awestruck by these simple little sentences that you can say. Later on, maybe I'll come back and do the authority, consent, and counsel advice maxims by S.S. Plubert, published in 1880. There are two instruments, either to confirm or impugn all things, reason and authority. It is more grievous to injure an alternate than a temporary authority. The authority of no man ought to prevail with us, so that we should not follow better opinions, should another present them. That goes back to theory, right? theory of gravity, theory of relativity, those theories stand true in fact until somebody else comes along and has a better theory about how it works, right? And then we all adapt to that theory. Reason and authority are two brightest lights in the world. To execute a deed, authority to execute a deed must be given by deed. That's spoken of in the Bible. In law, common opinion is good authority in law. To whom given? He who has authority to do the more important act shall not be debarred from doing that of less importance. One proprietor can exercise no authority over the common property against the will of the other. Consent. Consent is the united will of many persons interested in the same thing. Consent constitutes law. Consent and not concubinage constitutes marriage. Consent takes away error. Those consenting and those perpetrating are embraced in the same punishment. To consent to a thing is to perform it. To consent to a marriage is not possible before marriageable years. The unwritten law, common law, is expressed by the tacit and ignorant consent and customs of the people. Long sufferance is construed as consent. What that means here, and this was an important one for me to learn, because there were some things that had happened to me in my life, and as I started to learn the law, I was like, oh wow, I've got a cause of action here, and my mentor goes, you no longer have that right of action. Why? You've been barred by time. Well, time is just a figment of man's imagination, so we could have contract. I mean, nothing else in the physical realm here uses time. You know, the birds don't, the deer don't, the fish don't, none of those breathing animals use a calendar or a fucking clock. So what do you mean that time has barred me when it's nothing more than a theory? He says, here's my case in point, Derek. You get stabbed by a guy. You blow it off. 5 years later, the man wins $500,000 in a lottery. And now all of a sudden you decide that you're going to bring suit against him. You have been barred from bringing suit because long sufferance equals consent. Okay? You acquiesce to it. Long sufferance is acquiescence. And sufferance is something that you volunteer for, right? So, it is better to suffer every wrong than to consent to wrong. Nothing is so contrary to consent as force and fear. He who errs does not consent. It matters not whether a man gives his assent by words or by acts and deeds. Those who err are not considered as consenting. He does not appear to have retained consent who has changed anything through the menaces of the party threatening. Not cohabitation, but consent makes the marriage. He who does not forbid when he can forbid commands. He who is silent appears to consent. He who is silent is regarded as assenting when it is debated concerning his convenience. He who does not prohibit the intervention of another in his behalf is supposed to authorize it. Silence shows consent. He is not considered to consent who obeys the orders of his father or master. Counsel advice. Everyone is free to ascertain for himself or to have recourse to counsel. No one is bound by the advice he gives. After the deed, counsel is in vain. A wise man does everything advisedly. Of a friend. The advice of a friend should be regarded. Of many. The counsel of many are required in great things. In many counselors there is safety. In law, it is improper, unless the whole law be examined, to give judgment or advice upon a view of a single clause of it. hasty. Hasty counsels are seldom prosperous. All right. And he who pays in haste pays twice, baby. Thanks for joining me. We'll talk to you again real soon.